Can we agree to child support that's different than what's in a court order? Hi, I'm Bill Farias, founder of Farias Family Law, and this question came up just a couple of weeks ago. I had a gentleman who has a child support order in place. He was going through some difficult times financially, and he and his ex agreed that he could pay a lower amount for some period of time. Now, this ended up causing problems because the ex ended up going back on her word and asking for the full amount, which meant that this guy owed a ton of money. And so the answer to this question of whether you can agree to an amount that's different than what's in a court order is yes, you can. However, you want to make sure that you actually modify the order, because a verbal agreement to deviate from the amount that's set in a court order is not going to hold. So in other words, what can happen to you is exactly what happened to this individual, which is you have a word of mouth agreement. Hey, I can't afford this much anymore. Can we reduce it to this amount, at least for some period of time? Yes, sure, no problem. The issue is that's not enforceable. And so if the recipient later wants to ask you for the full amount, including everything you owe from the period of time that you were paying less, then you're going to be on the hook for that amount. You cannot go into court and say, hey, look, it's in a text message, we agreed to reduce it. You have to get it formally reduced, and the only way that you can do that is through a court order. Now, the good news is that you don't actually physically have to go to court to do this. You can utilize what's called a joint petition for modification that allows the parties to file in court and ask that the court process it administratively. And so as long as you correctly file, and as long as the request is not outrageous, as long as the parties agree to it and it's not going to harm the children, then generally the court is going to allow it. But the key message here is that you are better off erring on the side of caution and doing it formally rather than relying on a word of mouth agreement. Because if you don't have an actual change in the court records, then you technically are on the hook for the child support amount that's in the existing order. If you have any questions about this, you can call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can also find us on social at Farias Family Law. Thank you. Have a good day.